Good morning. Welcome to the joint Veterans Endorsement interviews for judicial candidates. At the outset, we would like to formally recognize and thank the sponsoring organizations for making today's event possible. Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber. We also will extend our sincere appreciation to our additional sponsors, community partners whose help ensures a professional, fair, and transparent endorsement process. Do not mention any of these sponsors during the interview time. That's just me reading. We'd like to thank Judge Jacob Reynolds, District Court 29, Judge Mary Perry, Family Division, Department P, Judge Veronica Bereshish, I think it is. That's a hard one. Judge Daniela Teramu, and Amanda Pellizzari. Got it right. Okay. We're honored to have you here today, Ms. Brewer. Before we begin the interviews, let's go over the rules format. Each panel, will introduce our name and our organization. You can introduce your name and the reason what position you're voting for. There won't be any need for debate because there won't be anybody here but you. We'll proceed with the interviews after that. Everything I just read, there's no debates. The format we'll give you 1 minute and 30 seconds per question. 30 to 45 seconds out, I'll put my hand up, and then I'll leave it alone. When the alarm goes off, then time is done. The panel members will not have any follow-up questions, so that's just for us. So whatever answer you give us is the answer you give us. After that, we'll give you 1 minute for a closing statement, and then at the conclusion of the interview, we'll take take pictures, and that'll be it. I have to note, in the interest of fairness and transparency, Veterans in Politics International and the Nevada Veterans Association will abstain from this interview due to the fact that VIPI LLC, whose president is Steve Sanson, represents one of the candidates here today. Therefore, Armed Forces Chamber will be sole organization conducting the interviews. Again, this is an interview for Family Division Department S, Kristine Brewer. Thank you.
Thank you.
Hi there, I'm Bradford Carlton with the Armed Forces Chamber.
And I am G.P. Edwards, Armed Forces Chamber.
Good morning, gentlemen. Nice to meet you. I'm Kristine Brewer. I'm a candidate for Family Court Department S in the Clark County Court. And I really appreciate your time this morning and meeting you.
Okay, so I'll let my colleague here, Mr. Bradford Carlton, start off with the questions.
Sorry, Bradford Carlton, Armed Forces Chamber. So I hear judicial candidates say all the time that the court system is broken. That often what they say is part of their little speech, right? What do you believe is broken about the family court system, and how would you recommend changing it?
I believe that there are changes that can be implemented, and I believe one thing that I would like to do is perhaps start a mediation process. There is an Ask a Lawyer program, and lawyers donate their time on Thursdays to assist litigants in answering questions. And it gives people access to justice. And I believe something that could be implemented is a similar program, getting volunteers to donate their time and help pro bono litigants to mediate their issues, because oftentimes it's just a matter of, negotiating, hey, where should we drop off or pick up? And if there's someone, the judge doesn't have the ability to do that, but if we can get someone pro bono, that may help a lot.
Armed Forces, J.P. Edwards, Armed Forces Chamber. My question is, what role should judicial discretion play in family court rulings?
I believe that judicial discretion is part of the statutes and the case law. And I believe that judges should follow the rules and use their discretion, because there are, even with the best interest standards, for example, there's what else could the parents be looking at when they come into the courtroom? For example, education is not specifically stated, and that's a standard or an issue that a judge can consider when making a decision.
Okay. Okay. As far as discretion goes, every judge has to have discretion.
Sure.
However, how do you prevent your personal beliefs from affecting your decision making when the legal standard is fairly clear?
That is a personal question. I'll answer it in a personal matter. I may not like it. However, it is a judge's duty and responsibility to follow the law. And I have seen judges that I admire say those exact words in a courtroom. They say, I do not like this. However, I am going to follow the law, and they will explicitly state the law. And I think it gives the courtroom, those in the courtroom, a sense of where the judge is coming from, and it makes the decision easier I've been a practitioner to explain to the clients receiving that information.
J.P. Edwards, Armed Forces Chamber. How do I put this? In your mind, what does the best interest of the child mean in practical terms?
The best interest of the child, I believe, is to have relationships with both parents. And I like to stay child-focused. Parents also have rights under the law. However, I believe that focusing on the child should be able to have the opportunity to have a relationship with both parents, and doing what is best for the child. And what's best for one child is not necessarily the best for the other child. And I believe that it's definitely driven by the facts and circumstances presented by each individual child, what is best for them. And I believe that the law does have that depth and breadth to be able to view each child individually.
Bradford Carlton, Armed Forces Chamber. So in the family court, you'll often hear allegations of domestic abuse. Many times they may be legitimate, many times they may just be allegations. How do you balance the safety of a potential victim versus the legal rights of a person who has simply been accused of something that has not yet been proven?
Thank you for that question. Domestic violence is a very serious issue in our community, and I believe it needs to be taken seriously. I also do believe that the rights of alleged perpetrators need to be taken into consideration as well, and that is a balance. And I have had extra training in domestic violence. I worked with Legal Aid Center of Southern Nevada and had hundreds of hours of extra training. And I believe that it's important to listen to both sides and take the evidence and balance it. And because the children, like I said, have the right to relationship with both parents, and everyone has the right to be safe, and everyone has the right to their freedom.
J.P. Edwards, Armed Forces Chamber. What steps should judges take to ensure children's voices are appropriately considered in court?
There is NRCP, the Nevada Rules of Civil Procedure. There's 16.215, and that is the child witness section. And the legislature has outlined the factors that must be followed in order for the children's voices to be heard. And I've also seen judges be creative, and I believe that that's part of discretion, is being creative. And some judges do interview children themselves in the courtrooms when that is presented to the court. And I believe that that is a viable option that I would consider, is to have the child come and do a short interview with the child. So and that would also streamline and bring down the expenses for the families.
Bradford Carlton, Armed Forces Chamber. Loud. So as we all know, legal services are expensive, and oftentimes somebody may not be able to afford an attorney. How do you intend to be able to handle someone who may be self-represented pro se, who may not necessarily understand court procedure?
The judges that I have been able to observe, I really admire, because they speak to the individual, and it is a very personal matter. And I do believe judges can give some procedural information. They're not allowed to give legal advice, but I do believe that people need to be listened to and given resources that are available. Remind the litigants there are resources in our community, and the legal self-help center is available. There's resources online. And again, taking that moment to hear what they need and being able to give the litigants what the next steps to take to help them.
J.P. Edwards, Armed Forces Chamber. How do you maintain professionalism and order when litigants are highly emotional or confrontational?
Family law is a very emotional issue, and I can't think of anything more important than, one's children. And I do believe that people possibly oftentimes need a moment and to have some compassion and grace for the litigants, for their emotions. And I do believe that I would bring that to the bench, but as well as being firm, because there needs to be an amount of decorum. And if folks need a moment to come back to, decorum, that's okay. And if they need a moment to take that outside, I would invite them to take it out, and then we can, gather our thoughts and come back. But it's a serious matter, and it's a very important thing that happens, but I do believe grace and compassion can play a part in that.
Bradford Carlton, Armed Forces Chamber. So back when I was an attorney, my family law clients were always my absolute worst clients because they lied about everything. And so when they come into court, they're not necessarily always going to be the most honest. They'll fudge things. As a judge, how would you be able to parse through the obfuscations and find the truth?
I think that you make an important point, because people certainly want to put their best foot forward in the courtroom, and sometimes they want to say what they think the judge may want to hear. And you know what? I've learned as a practitioner as well that, it's like an onion, you're peeling away the layers, and maybe it's more of a sin of omission than being, committing that sort of act. So I would want to take a moment and, get to know the litigant and let them show, and, it's a matter of getting to know someone sometimes and not holding that against them per se, because, are they under oath, or are we doing a motion hearing where it's argument? That's also should be taken into consideration, so that we're, the level of evidence that we're taking. Is it evidence or is it argument? Thank you.
J.P. Edwards, Armed Forces Chamber. In prior interviews, we've noted from the panel and from the judges, the candidates, that family court in Las Vegas is very busy. So that being stated, the family courts often carry heavy caseloads. How would you ensure cases are handled efficiently without sacrificing fairness?
the litigants deserve their day in court. They deserve their voices to be heard. And I believe having a calendar and managing a calendar efficiently and running on time. And I'm grateful that I'm healthy and I enjoy the law, specifically family law. And I would spend the time necessary because I'm sure from what I understand with the courts, yes, it's a huge caseload and, extra time is required. I'm ready, willing, and able to do that, what it takes. And having a staff that is professional and supportive of helping move the cases along. And I believe running on time is very important for the litigants because they want decisions. And waiting too long it makes people feel less, confident in the system.
Bradford Carlton, Armed Forces Chamber. I'd like to ask you a personal question. Why do you want this position? Why are you running for office?
I believe that public service is the highest calling that one can have. And I really believe in serving the public. I believe families are the most important asset that we have. And I believe that families last beyond the rearrangement, if you will. And the relationship between child and parent is a lifetime, if not forever. And I believe that I have the patience and I do care, as I've shown through, choosing work that is not high paying and doing pro bono work. That is how I've shown that I care, and by volunteering in the community. And I believe I will bring that compassion and empathy and making decisions and maintaining confidence in the public.
JP Edwards, Armed Forces Chamber. So we've heard before from other candidates, as well as yourself, as far as the pro se litigants, and they come in by themselves and they don't understand what's going on. I myself went through that. The legal jargon can be intimidating. In some cases, just walking in the courtroom can be intimidating because you understand it's going to be a traumatic effect. How do you, sitting on the bench, how do you ensure fairness when one party has significantly more financial resources than the other?
This is where judicial discretion can come in, is the law does allow during a divorce the party that has more access to funds to make the playing field, on an equal footing by ordering attorney's fees. And also the judges, I've seen some recent cases, you cannot proceed and to a final decision unless there is the information necessary for the judge to get to the end. So one thing I would like to do, if attorney's fees are awarded and the side that's ordered not paying attorney's fees, I would like to have a calendar to ensure that those fees are being paid on time to keep the cases progressing and thus level the playing field.
Bradford Carlton, Armed Forces Chamber. Oftentimes, children will have a preference for which parent may have more custody of them than they may wish the other parent to have. How do you make a determination of what amount of custody each parent will receive?
The law gives us a framework in the best interest, and I believe that the law must be followed. And again, we talked earlier about having the child's voice heard through, the proper mechanism. And I think it's important to look at all angles. Is this their thoughts, or is it coming from one side, one parent or the other? And I believe that taking all of the information into account is important. And again, the bottom line is what is best for this child. And, but I believe that maintaining the relationship between the parents and the child, that is incredibly important, as well as the child with both parents, because children, they don't necessarily know what's best for them. And that's why, as adults, we are charged with, it's a very high duty, I believe, to take care of the child.
JP Edwards, Armed Forces Chamber. You've touched on a lot of topics that just didn't ask questions. Children having their voices heard, the emotionally charged condition of the whole proceeding. My question is, how should the courts, yours as well as the term plural, how should courts handle cases where children may be exposed to parental conflict or alienation?
Those are very serious issues, parental conflict and alienation. And that is something that lends itself to a lot of manipulation and control, perhaps, by the parties and litigants coming into the courtroom. And I believe that looking at the information, the supporting data or data, if you will, and the evidence is critical to meet through that, because in and of itself, those words are charged and those issues are charged and must be looked at very carefully by the very nature of what we're talking about. Is a parent alienating the child from the other parent? Those are very serious allegations, and all of the information and data must be considered.
Bradford Carlton, Armed Forces Chamber. So it's not always the litigants that may be causing problems in the court. Sometimes it is the attorneys. What steps would you take if you believe an attorney was acting unethically in your courtroom?
That's a very, very good question. If someone's acting unethically, again, there are rules that lawyers must abide by, and I would expect and anticipate that the lawyers will follow the rules that we have, but from the Nevada Supreme Court with regards to professional ethics and responsibilities. And I would follow the protocols. It's very serious if a lawyer does not follow that. And there are ways to elevate that. There are ways to bring that back to center, if you will. And I've seen situations where a judge can say, "Counsel, are you really going to do that?" And it can bring it back to center. And, because counsel will run as far as you let them. So if the judge doesn't have a tight courtroom, attorneys will run amok and afoul if the judge lets them. And I believe bringing it and keeping it professional, following the rules. And I want the litigants to know what they can anticipate and have confidence in my courtroom. And I want the attorneys to know that that type of behavior would not be acceptable.
JP Edwards, Armed Forces Chamber. If it isn't already part of the process or part of a judge's discretion, how would you handle a situation where the parents can't seem to communicate during the proceedings?
The modern world gives options, and I believe that parenting applications are one of those modern options. And, putting some boundaries on that there can be communications through a parenting app, and keeping it brief, polite, and sticking to just the child focused issues. And I wouldn't want to give too many rules up front, because I do believe that, parenting needs to have a little bit of breadth, if you will. But if they can't do it, then, You can communicate once a day. You can communicate with 2 or 3 sentences. You can communicate with no more than 20 words. And these are things that I've seen implemented when there's super high conflict, but I wouldn't start there. Those would be, more restrictive issues that if necessary.
Bradford Carlton, Armed Forces Chamber. I'd like to pose a hypothetical. So in my time working for the courts, I would often see before a hearing, before bringing the litigants in, a judge would ask that counsel would come into chambers to discuss the case first. In my hypothetical, only one of the parties has counsel, the other is pro se. In that situation, do you bring everybody in still, or do you just bring in counsel?
If one chooses to represent oneself in the legal process, they are acting as their own counsel. I believe they should be treated with the same deference, respect that counsel would be, and that the appearance of impropriety to only pull counsel back is too great. So I believe that it would be all or nothing. That is not something that I would engage in, because we are not supposed to have ex parte communications from the litigants, attorneys to the judge, or the judge going back to the litigants or the attorneys. It would not be appropriate in my personal and legal opinion.
JP, Armed Forces Chamber, how do you differentiate between how do you differentiate between legitimate safety concerns and tactical allegations in litigation?
I believe, again, that looking at the data, the evidence, the information, and I'm looking for specificity. And as a practitioner, that's what I've done. Because if something is vague or ambiguous, it doesn't have the same ring to it. I'm looking for specific dates, times, incidences, and is there supporting data or evidence to go with that? Because otherwise, I'm not having confidence in it. So on the bench, I would be looking for that. What specificity is there? And what information and data supports that? Because again, these are very intimate, important issues that we are looking at.
Bradford Carlton, Armed Forces Chamber. In your opinion, what role should mediation or ADR or alternative dispute resolution play in family court?
I think mediation and ADR can play a significant role. And I believe that it's much more preferred and encouraged. And that is how I have been trained by mentors, and even what I've seen with the judiciary. Moms and dads know their children and their situations better than anyone else. And a good mediator can help lead and guide to a resolution, because in the trial setting, the judge gets to see only a very narrow portion of the family's life can be brought in. But in a mediation situation, albeit it's professional, it's more relaxed, and it's off the record, and negotiations can be more free-flowing. And, a guided resolution is the goal, in my opinion, is that mom and dad can have that co-parenting and beyond, the dissolution of the relationship.
JP Edwards, Armed Forces Chamber. So in the past questions, we've talked about, he just mentioned the mediation as an alternative. We've talked about putting the communication with the parents in the forefront so that they can communicate. We've talked about attorney, their attitudes. We've talked about the litigants and their attitude. There are some situations where one client or one defendant one parent may have more financial than the other person. There may be one where the parent's accused of being alienated. Sitting on the bench, how do you decipher between a parent that has that emotionally charged family that's in their ear, and you can tell by when they're in the courtroom, they're trying to proceed with, as well as they can, knowing the law, but they also got the parents charged in the ear and they're fired up about that. How do you run that specific proceeding to get them to understand, don't make a mistake, but you don't want to seem to be favoritism towards one, because you can sit and say, okay, are the parents family talking, or are they talking? So sitting on the bench, how do you determine to navigate that, where you let them get their say-so, but you also want to make sure that they're not doing something to pull themselves further away from the custody?
Families are layered and they're complicated. And I believe that it's really important to focus on, the parents that are right there in front of me. And that the relationship, again, with the child or children at issue are with their parents, the parents that are right there. And, certainly it's a benefit to have the community of support. However, I believe that, the parents should be communicating with one another about the best interest of their children. The parents are the ones that are to make decisions about their children's health and welfare and medical and religion. And it can be challenging to turn off all of the other outside. However, I think that it also, as we laser focus on that, it can help build that bridge and to better communication and to the focus. And certainly it's up to each individual, because everyone's going to make their own choices about how they behave. I would encourage mom and dads to focus on the communication with one another about how they're going to move forward with, for the best interest of their children.
Okay, we started early, so this will be the last question from this panelist here.
Carlton, Armed Forces Chamber. So sometimes one of the litigants may not want to engage in the process. Maybe they just are deluded. They don't think this is actually going to happen. They are just rolling over, just whatever. In a situation like that, where it's clear that one of the litigants is just whatever they want, just let them have it, how do you ensure fairness and justice?
I believe it's really important to talk to that individual and let them know what their options are. Because I have been in courtrooms where it looks like that very thing is happening. And I have seen judges take the time and query that litigant and make sure, hey, and protect their rights, because everyone has the right to be heard. And our statutes have the evidentiary procedure. So if it's an initial custody proceeding, for example, the judge must make those findings of facts and conclusions of law. And I believe that the more opportunity that you give the person, the litigant, the parent to participate, the more understanding hopefully can come. So it's not going to happen at the initial portion. There's a lot of opportunities along the way to make sure that their voice is heard and that they are having input in the process and the final determination. And again, we can always come back, because the best interest of the child is what's at issue.
J.P. Edwards, Armed Forces Chamber. So that concludes the interview process. We like to give you 1 minute to, again, reiterate and to clarify again what position you're going for, why we should vote for you, and how you can be contacted.
Thank you very much. Again, my name is Kristine Brewer. I'm a candidate for Family Court District, Department S in the Family Courts. I have been a family law practitioner for this is my 23rd year, and I care deeply about the families in our community, and I have shown that by taking pro bono cases, by helping those that have had less access to justice, perhaps, or lower income. And I believe that I have a temperament of empathy and understanding, and I'll bring that compassion to the bench, but also to be firm and follow the rules. And I want to be able to be consistent so that practitioners and litigants will know what to expect. I will follow the rules, and I will want to make, it's up to a judge to keep their calendar and to keep it going and making decisions in a timely manner. And I believe that's important. Thank you so much for your time and attention today. It was terrific. Thank you.
Thank you. That will conclude this segment of the Joint Veterans Endorsement interviews for the judicial candidates. And again, we'd like to pay sponsorship to Judge Jacob Reynolds, District Court 29, Judge Mary Perry, Family Division, Department P, Judge Veronica Beresh, Department 5, Danielle Teramu, Department 28, and Amanda Pelizzari, Department 1. That concludes the interview for this morning. Thank you.